sorry. Oh, louder. Here you go. It's never been a problem for me. The issue in this case is whether the circuit court has jurisdiction over claims that the apportionment in 2010 or 12 violated the Article 3, Section 16 and 21 of the Florida Constitution. The Florida Constitution provides for jurisdiction in this court. It provides for a procedure to determine whether the apportionment is valid. It provides for input from all interested and adversary parties, and then it provides that a judgment of this court shall be binding on all citizens of the state. We submit that that procedure renders jurisdiction in this court exclusive, and that any claims must be brought here, and in fact have been brought here. You may remember we were here a year ago on these claims.
So if they had, you're not asking, though, for a complaint that was filed in circuit court transferred here so that we, in fact, transfer it back down for fact-finding. In other words, like we did in 1972 when we recognized that with factually intense claims that they needed to be adjudicated. You're not suggesting that we take jurisdiction.
No, we are not, Your Honor.
And why is that? In other words, wouldn't that be the alternative if the idea is that only the Supreme Court has jurisdiction to adjudicate these claims, that we would then transfer the case here and then transfer it back down? I mean, if that were the if that were the legislative, the constitutional intent.
Despite the fact that this court has at some time said we retain exclusive jurisdiction, I don't think that's ever been tested in that subsequent claims had been filed in this court.
Well, there was, in 1972, there was a series, of claims that were brought, and ultimately several were adjudicated through commissioners being appointed.
Well, this court did not reserve jurisdiction in 2012, and we believe, and it said that its decision was final, and we believe that the reason it did it is because it had already put all the work in there, and if it had retained jurisdiction to consider subsequent claims, the whole purpose of the Constitution, which is to obtain some finality in the process and certainty in the process, is going to be eviscerated.
Not to, and I'm sure you're aware of it, I think it happened maybe before you got in the case, but you're aware that the position of the Senate, the House, the Attorney General was that because with these new standards, they were so factually intense, especially as to the intent, whether to favor or disfavor incumbents, that the argument of all of those parties was we should just basically do a very superficial review and leave it to the circuit courts to develop the factually intense claims. Understanding there's no, you can make that argument, but we're trying to do something for the, understand the Constitution. Was the Attorney General, the Senate, and the House just leading us down a path that would have put us right here, that if we hadn't even made an attempt to look at the objective data, that and subsequent claims were brought, they would have said, too bad, you really don't have jurisdiction?
Well, Your Honor, I do remember I had watched the 2.5-hour oral arguments in that case, and both Mr. Carvin and Mr. Meos told the court that all you should do is a superficial review, that you don't have time, you don't have the structure to be able to do it. And I also remember this court squarely rejecting that argument, both at the oral argument and in the opinion itself. In fact, I'd like to quote from the opinion at page 609, where the court said, to accept the legislature and the Attorney General's position that this court should not undertake a meaningful review of compliance with the new constitutional standards in this proceeding, but instead await challenges brought in trial courts over a period of time would be an abdication of this court's responsibility under the Florida Constitution. This approach would also create uncertainty for the voters of this state, the elected representatives, and the candidates who are required to qualify for their seats. So this court rejected that argument and said, no, we're not going to do that. We're going to undertake a meaningful review. And you put a lot of work into that review. And in fact, Justice Pariente, you lamented the fact that you only had 30 days to do all this, that it was a lot of work. And you said the solution for this is to amend the Florida Constitution. You never said, oh, but at least they get to do this all over again in the circuit court. This is only a facial review. This is only superficial. And now they're going to go back and do it all over again for 2014, 2016, 2018, 2020. You said, no, this is it, and we really need more time in order to fulfill our responsibility. But you did it within the time prescribed in the Constitution. But what they can't do is say, on the one hand, you're the ones that conduct the meaningful review, and on the other hand, now they also get to come back and go to the circuit court. We certainly didn't argue that both things were true. This court also, in Roberts versus Brown, in a ballot summary case, decided that when the Constitution gave this court jurisdiction to determine the ballot summary and whether it complied with the requirements of the statutes and Constitution, that jurisdiction was exclusive and that there was no jurisdiction in the circuit court, even whether pre or post election or voting, to undertake such a review. And the same is true here. The Constitution grants jurisdiction in this court, and therefore the jurisdiction is only in this court, and it's exclusive. And I just want to reiterate my point, Justice Pariente, to your question. It is going to resolve nothing if what you do is say, well, we undertake this very thorough review at the beginning, but then come back to us later, and then we'll transfer the case to the circuit court to act as commissioner. That creates just as much uncertainty as...
Well, and again, we could have an academic discussion about the idea that what the court was doing, and I think obviously the opinions will speak for itself in our interpretation, is to try to give some certainty that with all of the objective data, that it either complied or it didn't comply in part. And in fact, that was in deference to the legislature, so that the House has now certainty that their plan is, in fact, it's not even being attacked, because on all of the objective criteria, it met it. So if we hadn't done that, they could have been in uncertainty. But the fact that you're saying because the court attempted to do some objective review and emphasize over and over that it was a facial review, that if there is evidence in the record that is disputed, of course, that the plans were drawn with intent to favor or disfavor incumbents, something that was described as by the Senate a Sisyphean task to do that when it's factually intense, is, I think, what I'm concerned about is it actually frustrates the intent of the voter. So how do we, in other words, you're saying, well, because we endeavored to do something, therefore, there is nothing more that should be done. And I'm just having trouble with understanding how that effectuates the constitutional intent of the voters to make sure that these plans do not discriminate against or in favor of incumbents.
I don't think it's just because you did something. I think it's because the Constitution provides for jurisdiction in this court to review it. And
but that's where we go back to the issue that our precedent from 1972 through 2002 was always clear that we did not have exclusive jurisdiction, and especially in 2002, in an opinion that was really the majority of this court. So my concern is that if that's a good idea for the future, that we have somehow, the voters have a right to rely on our precedent, that subsequent challenges would be allowed.
Let me address a comment that you made about the 2002 case, and really it goes to every other case. This court has never said that it reviews apportionment for compliance with Article 3, Section 16, and now Article 3, Section 21. Whatever the explicit constitutional requirements are, this court has never said, we were going to review this, and then later you can file a circuit court action as an as-applied challenge. When the court has described an as-applied challenge, what it has meant, and specifically in 2002, what it said is federal equal protection claims, Voting Rights Act claims. So, and that's logical because this court doesn't have any control over that anyway. You really couldn't, even if you wanted to, even if the Florida Constitution wanted to, could not prevent plaintiffs from filing federal claims either in federal court or probably even in state court, because the federal statutes provide for concurrent jurisdiction. So there's really nothing you can control on that end. And in 2002, that's exactly what you did. You said, we're going to review the Article 3, Section 16 requirements. We're not going to review these federal claims, which are fact-intensive. And I think that's perfectly consistent with what you did in 2012, which was you considered Article 3, Section 16 and 21 claims. You did not even address, and nobody even addressed, federal claims. And we make no argument here, and we concede that they can file federal claims, whether in state court and federal court. And even if I didn't concede it, they would still be able to do it, because that has to do with federal jurisdiction. What they can't do is file claims alleging violations of Article 3, Section 16 and 21, because the Constitution provides this court with the exclusive jurisdiction to do so. If the court has no other questions, I'd like to reserve the remaining time for rebuttal. Thank you.
Good morning, Your Honors. May it please the court. My name is Adam Schachter. With me at council table is my partner, Gerald Greenberg, and we represent the respondents. The Fair District Amendments were supposed to fundamentally change the way Florida's legislators draw redistricting maps. That change, quite simply, will not happen unless Floridians can bring lawsuits like this one in circuit court.
But let me ask you this. Did the amendment, understand it established additional standards, but did it change the structural process for this court's review of the legislative redistricting plans?
Like you said, Justice Kennedy, it added another important standard with respect to intent. It didn't change the Article 3, Section 16 framework, but that's...
Okay, well, let me ask you, okay, that's what I thought. That's still there, and that's the framework we operated under last year as we went through this process. Let me ask you specifically about subsection D of Article 3, Section 16, the first sentence there, because I just think that's a sentence that kind of looms over all of this. Because there in the Constitution, the people of Florida have said a judgment of the Supreme Court of the state determining the apportionment to be valid shall be binding upon all the citizens of the state. Now, I think it's your position that that doesn't really mean what it says.
No, I don't think that is our position. What I would say our position is that that statement applies to the determination that this court made. And this court was very careful in making clear that it made a determination of the facial validity of the plan.
But the determination we make, we're called on to make, it doesn't say anything here about whether we make a facial or as applied determination of validity. It says that we're called on to determine whether it's valid or invalid. And it says that the determination that the apportionment is valid shall be binding. So it seems like to me you're having to rewrite that provision of the Constitution. Now, I can understand that places some limitations on what can happen in court. But it would seem to me that that's exactly what was envisioned by the placement of that provision in there. It is designed to bring finality. And that may mean that there are some things that don't get litigated. But this is a process that is designed to, what took place here last year was designed to be binding on all the citizens of the state. I'm having trouble understanding what somewhere else in the Constitution says that binding doesn't mean binding.
I believe that Article 3, Section 16D, which you're referring to, can be reconciled with the jurisdiction of the circuit court to hear these as-applied claims. And the reason it can be reconciled is because in Article 3, Section 21, the voters of Florida overwhelmingly made it the law that intent is now an issue that must be considered. And in order to consider the issue of intent, as the United States Supreme Court has made clear, and as this court has made clear, that is a fact-intensive inquiry. It is demanding of evidence, and it is almost Sisyphean to do it based on simply lines on a map.
So you're saying that implicitly, that provision that was adopted implicitly changed the structure for our review. Is that
well,
what you're saying?
I don't know that it changed.
I think that's what you're saying, because it didn't do it explicitly.
Well, but my
Did
point, respectfully, Justice Kennedy, I think that nothing changed because in 2002, when Article 3, Section 16D was still there,
But if it didn't change, why are you talking about the new amendment? I don't
because I
understand.
think the need for the circuit court jurisdiction for an as-applied claim is even greater now than it was before. In 2002, what this court said, it didn't say that you can bring the as-applied claim solely for equal protection or federal claims. At the very beginning of the court's opinion, it said this court will pass on the facial validity of the plan only, and any as-applied claim will fall to the jurisdiction of the circuit court later.
Well, let me ask you about this distinction between a facial challenge and an as-applied challenge. I'm having trouble understanding how that concept, that dichotomy, applies in this context. Because when we think about a facial versus an as-applied challenge, we think about a situation where a statute can have certain applications that are constitutional, but there may be particular applications in a particular factual context where the statute, as applied, is unconstitutional in that particular factual context. Now, that's what that distinction means. Here, we've got a plan. It's applied. It is a singular plan. They're not different applications of the redistricting plan. So it seems like to me that what you're trying to do is you're trying to use this distinction. You're really turning it around and as a way to just bring in additional evidence. You want to bring in new facts, additional evidence, and you're using that distinction in a context where it really doesn't apply. And I understand we've made references to facial validity and things like that, but I just don't understand why that concept actually fits this context where we have a plan that has really a singular application.
The distinction between facial and as-applied claims is without question different in the redistricting context. And it's an evidentiary difference. And I think the difference is best illustrated by what can be looked at in each review. What's important here, I think, is not only that the claims that we are asserting in the circuit court were not adjudicated by this court. What's important is they could never have been adjudicated by this court. And so, by necessity, if there is evidence out there that would show that there was, in fact, improper intent with respect to the Senate redistricting plan, whether or not that evidence is enough for us to prevail on the claim, we think it is. The defendants surely disagree. That's what a trial's for. But the important point here is that if it doesn't happen in the circuit court, that evidence will never be viewed by anyone. And the result of that will be that the Fair Districts Amendments will be nothing more than words on a page, because intent, again, is particularly fact-intensive. And as this court recognized over and over again in both of its 2012 opinions, it is nearly impossible to discern intent by looking simply at lines on a map and numbers on a spreadsheet.
Could another lawsuit be brought next year?
Conceivably, yes, but that's circuit court.
And the year after that?
I think the way that is handled is by the circuit
That's
court.
consistent with your position, right? This just never ends.
It is consistent with our position, but I would have 2 points on that. First of all, circuit courts are capable of handling that type of, if it's duplicative litigation or litigation that's purely tactical, circuit courts have ways of dealing with that. Defendants can make motions. There's ways to deal with that. But I think the more important
Don't you think the language of the Florida Constitution really intended for all that not to happen?
I think that the language of the Florida Constitution was intended the way it has worked, which is for this court to pass on the facial validity, which does give some degree of closure and finality with respect to these maps. You have a sitting legislature. They're able to pass laws.
Well, how are the claims in this circuit court really different than what we've already looked at?
Well, I think for example, and just so we're clear, this is no longer some abstract concept. It is already happening. In this circuit court case, there has been third-party discovery where documents have been produced showing that, in fact, there was what we believe to be improper intent in drafting these plans.
So it's
And-
the same claims with just more evidence, as Justice Kennedy suggested.
And
Is
I
that
think
right?
no, it's not the same claim, because I believe there is a lawful and real and appropriate distinction between as-applied and facial claims. There's no question it uses the same words. There's no question it seeks the same relief. But this distinction between facial and as-applied claims, albeit somewhat unique in this redistricting circumstance, is very real, and it's very appropriate, and it's been recognized time and again by this court and other courts. And if you walk through the case law leading up to 2012, that proves the point in some respects, because in 2002, like I said, this court said any as-applied claims may be brought in a circuit court, not just federal ones. And 3 months later, that's exactly what happened. In Foreman v. Senate, which was a state law claim, it was brought by Marion County Circuit Court residents in Marion County Circuit Court alleging violations of the Florida Constitution. And that case made it up to this court again, and not once was there a suggestion that the circuit court did not have jurisdiction to hear it. 3 months after that, in Brown v. Butterworth, again, there was an express ruling that circuit courts have jurisdiction to hear these types of as-applied claims. And then we get to 2012, and as Justice Pariente pointed out, it wasn't even a matter of dispute before this court. The petitioners here made the exact argument that I'm making right now, which is these fact-intensive inquiries should by necessity be heard by the circuit court, because the circuit court is particularly well-suited to hear them. Let me address briefly Roberts v. Brown, which is really the only case that petitioners rely upon. That case is distinguishable in numerous respects. Most importantly, it is not a redistricting case. Every other case that I've just discussed is a redistricting case. But even more fundamentally, it involves advisory opinions. And it is well-established law that the only court that has jurisdiction to issue advisory opinions is this court. In addition, the constitutional issues in Roberts v. Brown were explicitly not reached by this court. In footnote 2 of that opinion, the court made clear we are not reaching the constitutional issues. Those are not justiciable here. The issue was simply whether the court had jurisdiction to hear the facial claim in there. That is fundamentally different than what we are arguing here today and what we are bringing in the circuit court. Let me also address briefly the Constitution itself, because I think there's an important point here. Although Article 3, Section 16D, Section 16 certainly provides a framework for evaluating these claims, it most certainly does not say that the Supreme Court shall have exclusive jurisdiction. It doesn't use the word jurisdiction, it doesn't use the word exclusive. But even more importantly is Section 21, and that's the provision under which our claims actually arise. And again, Section 21 makes intent the critical inquiry, and that's what our claims are here, and that is the claim that requires discovery, and it requires discovery and evidence that this court never has looked at and never could have looked at.
Is the issue we're dealing with whether the circuit court has subject matter jurisdiction or whether the bringing of the lawsuits will interfere with the binding judgment of this court? Nothing, as I read Judge Terry Lewis's order, precludes the petitioners from arguing principles and their different, whether it's res judicata, law of the case, or collateral estoppel. Because for me, you said, well, yeah, they could bring claims once a year. No. If you're alleging there was improper intent and you're going to develop evidence, if there becomes a judgment of the circuit court that says we do not find improper intent, that from the facts that you develop, you can't bring another case the next year unless you're saying there was a fraud on the court. So there's finality in that judgment, and the way that the courts deal with subsequent challenges is they use principles such as, again, and I know they're different for different purposes, but that will have preclusive effect. So would you agree that the issue of whether there can be some res judicata, law of the case, whatever, in what happens before Judge Lewis is really not before us in this extraordinary writ proceeding?
I would absolutely agree, and I would take it even one step further.
But I mean, so that is a caution, because if, as Judge Lewis says, if you think you can rehash your arguments, you're going to be disappointed. I mean, he's very specific about that in his order.
There is no question about that, and we conceded that, and I conceded again here today. If we show up at trial of this case and present exactly the same objective evidence and data that was before this court, or even substantially the same, and again, I agree with you, I don't know if it's going to be called res judicata or law of the case, but the circuit court will have little trouble in saying this has already been adjudicated.
But under that theory, whatever binding effect exists wouldn't apply to different plaintiffs, would it? Because for collateral estoppel and res judicata or any of those sort of principles, you've got to have the same parties.
I think while technically it may not be the lawful proof, but and the circuit court has said this already, whether there's identity of parties or not, if the claim itself, and what I'm saying is,
Well, it sounds like we're kind of making up the law as we're going along here. You're going to say we're going to apply a doctrine to bar claims, which really, when the doctrine doesn't really apply.
well, I would use the same term that the defendants have used here, and this is that, again, if we show up at trial and our claims, which includes the evidence in support of them, is indistinguishable from what was put before this court.
I'm talking about different plaintiffs. I'm talking about I'm talking about plaintiffs who were entirely different from the plaintiffs who were involved in this before. They just decide a year from now or 2 years from now that they don't like the redistricting plan, and they get maybe a different set of lawyers, or maybe they get you. And they come in and they've got another challenge. What is to stop that?
I think what would stop that would be considered binding precedent from this court, having ruled on the exact same claims, whether it's the same plaintiffs or different plaintiffs.
How do we know this court's ever going to rule on it?
Well, I guess
We don't know that. We don't know that this case is ever going to come to this. The case that's being litigated in the circuit court is ever even going to come to this court, do we?
I may have misspoke. What I meant and what the circuit court said here is that the circuit court would, if the claims are the same, the circuit court would have little trouble in following the ruling of this court. If it's the same facial claim, essentially, this court has ruled on it. But I don't want to get off track here, but that is not going to happen, and that's already not happening. The claim is already different. The proof is there already. The circuit court will already be looking at things that this court never could have looked at.
But the point is, under your theory of the way this operates, there can be a succession of claims, maybe with different plaintiffs, but it can go on and on and on, and we can be litigating this redistricting plan over and over and over again for the next decade.
There is no doubt that because of the Fair Districts Amendment, that there is going to be some necessary time to make sure that the Constitution has meaning. But the Florida voters wanted that.
Could I ask one question,
Sure.
not quite as heated as we have? You would agree that in matters such as Public Service Commission, this court has exclusive jurisdiction?
I'm not perfectly familiar with that area of the law, but yes.
Well, I'm going to the point that I'm not sure that in the Florida Constitution, as interpreted, that on each occasion where it is determined that this court has exclusive jurisdiction, that those magic words are utilized. That's what I'm looking to. There are certain matters, a bond validation exclusively comes to this court. No DCAs get involved in it. And I'm not sure that those magic words are used each time. That's what I would think that we would look to the Constitution to see how the words are used in the Constitution.
I think that's right, and I would say, well, I have 2 points. First off, yes, I think the Constitution, not only Article 3, Section 16, but Article 3, Section 21, which raises this intent issue, we think commands a factual evidentiary inquiry that only the circuit court can do appropriately. But I think we also go back to the case law then. And as I discussed earlier, the evolution of the case law in this particular area, redistricting.
Well, I understand every argument that you've made all along. I've heard every one of them.
Okay.
I'm asking about the language in the document itself. Are those magic words required? Because you're arguing that a question has been propounded to you with regard to the wording of the Constitution implies that this court has sole and exclusive jurisdiction. So that's the reason for my follow-up question is that in other areas we have sole and exclusive jurisdiction. And are those magic words used there? Are they essential? Are they necessary? Are they required?
Well,
it seems to me it's a very direct
Yeah,
question.
I don't think they're required, but obviously if they were there, it would make this a very different case. But what's
Well, they're
important
not
here is
there.
that
I
they're
mean,
not there.
that's the point of it, is
Yeah.
that they're not there, yet exclusive jurisdiction is there, is here.
Well, what Section 16 provides for is exclusive jurisdiction for this court to do what it did. And what it did was a facial review on facial claims. There's nothing in Article 3, Section 16 that could be read to confer exclusive jurisdiction in this court for these claims.
Okay.
And I think that's where the distinction is. I think particularly reading Article 3, Section 16 with Article 3, Section 21 makes it plain that the jurisdiction to hear those claims falls outside of what this court did and does because, again, that facial review could never reach the critical issues that are raised by the claims in this lawsuit. I would end by simply saying that the Florida voters, again, passed these amendments to change this process. This allowing them access to the court is the way to effectuate that change. Those doors should not be closed. If there's nothing further, thank you very much.
Thank you. Rebuttal?
Thank you, Your Honor. There's really no way around the fact that if this court determines that there is jurisdiction in the circuit court now, it opens up, it may not happen, but it certainly opens up the possibility for serial redistricting litigation. There's no way around the fact that res judicata requires identity of parties. There's no way around the fact that another plaintiff can be found to file either a claim based on one of the 8 districts or one of the 22 districts that they did not file, or even the same districts.
Would you agree? I mean, I think we have, obviously, this is an important question, and I appreciate the advocacy on both sides. With the advent of the intent aspect of the Constitution, I would suspect that those that brought this constitutional amendment were either not thinking of every single possibility or in reliance on the 2002 opinion, assuming that factually intense claims could be brought in the circuit court. The fact that it may be, in figuring out how the intent, something that the voters felt very strongly about, intent not to favor or disfavor incumbents, the gerrymandering we hear so much about, it may be a little messy till we get the law straightened out. But what I'm concerned about is that you're asking today to say that that mess was never intended either by the voters or by the constitutional framework. We had if they were going to do something, they had to do it, because no one's saying it should come up here. You know, again, I'm not hearing either side say, because that's how we would monitor it, is have it all here and we'd send it back down. No one's asking us to do that. But nobody suggested in that 60-day period that we should have evidence taken. You know, we didn't consider expert affidavits because we said we're not going to consider things. So really, I think in fairness to how this is working, if this had all been brought to the attention of the court, then we would have had to come up with some procedure where full discovery was allowed in that 30-day period, where the circuit court took testimony on an expedited basis. Correct? I mean, that's what we would have had to do. Or would someone have said, we can't do that, which is what the Senate said. It's too factually intense. Wait till afterwards. So I guess my frustration about this is that it's not in a neat bow. I mean, I understand that, but I feel like we're getting a different argument from the Senate than we got in the initial case about the factual intensity of these claims, and nobody ever said there wouldn't be a chance to litigate these factually intense claims after the initial judgment was entered. And so what is your...
Honor, let's remember what you did in 2012. In Apportionment 1, you invalidated certain districts based on the intent to protect incumbents. You applied that provision to the evidence that you had, to the circumstantial evidence, as courts have done throughout the country in different contexts. Based on circumstantial evidence, you said that those districts had been designed to protect incumbents, and I think specifically District 10 in Orlando, and you invalidated those districts. So you were able to determine from that circumstantial evidence the intent. And courts have never said that based on a provision like this, or when legislative intent is at issue in a case, we can now go beyond the circumstantial evidence and depose legislators or take evidence. Courts have historically looked at the circumstantial evidence of legislative intent. So I think the amendments were designed with that in mind. They didn't contemplate that this court was going to order evidence. They contemplated that the court was going to look at the circumstantial evidence and determine it on that basis,
So
which is
again,
exactly what you did.
The fact, though, that we took that evidence in 1972 and in subsequent years, that, I think, do we consider that as precedent that was contemplated, and then in 2002 we said no, these factually intense claims are going to be brought in the circuit court. So if we were to reverse ourselves now, wouldn't we really be wouldn't that create unfairness for the respondents here? And that's what
No,
I'm
Your Honor,
concerned
because the
about.
respondents specifically, again, we already lost the argument that you should only do a superficial review. We lost that. And you did a very thorough review and put a lot of work into it and said, I can't believe we're doing this in this period, but we are. So having lost that argument, that's where we are now. That's the universe that we have,
you're
and that's the
saying-
argument they made.
Okay, so I think that your argument is that we have already addressed this argument in the way that we wrote our prior opinion. But if we disagree that because that specific issue was not litigated, then it really
I'm sorry,
is
which specific issue are you
the
talking
specific issue as to whether it didn't preclude any
Oh, I see.
claim that required factual
Well,
development.
You certainly did not explicitly say that, or we wouldn't be here today. But certainly your concurring opinion in Apportionment 2 seemed to assume that there was no alternative, that this was it, and that's why we need an amendment to the Constitution. You never said, well, hey, at least we've got a whole new series of cases going.
Well, the idea is I agree with you that I like the idea that this could be done in a expedited fashion, but the reality is with intent, which is factually intensive, it's just the question of, it should be able to be done in a shortened period of time, but the 60 days is too short. So,
But again, the legislative intent has always been determined based on the circumstantial evidence. There isn't a case where an appellate court or a trial court has said, well, what was the intent of the legislature? Even if it's a discriminatory intent under federal law, they've never said we have to determine discriminatory intent by deposing the legislators.
Well, that issue's not before us today as far as deposing.
I'm sorry, as far as
anyone,
what?
is it? That issue's not really ripe for decision. I mean, are you saying that if we decide today that the case can proceed forward, that we are saying that each legislator can be interrogated in a deposition?
No, I'm not saying that. I'm
Okay,
responding
well,
to
that's-
Justice Pariente's question
okay,
about
well,
what evidence you took
Those
into
two, I see those totally different issues.
I understand, and they may be, and in fact, there's a case pending in the first DCA right now on the congressional side. But what I'm
When we
responding
start
to,
mixing those, I mean, we become really muddled in what we're really talking about. As I
I'm-
understand it, it is the jurisdiction of the trial court, circuit court, to proceed with an action that's been filed there claiming a constitutional violation. That's what we're dealing with.
absolutely, that's what you're dealing with
But
here.
that's where the direction of this litigation is going, isn't it?
I'm sorry,
To
that-
be able to take discovery on intent, isn't that the direction that's going?
Yes, then they've
mean,
requested that, and the court has denied that pending an appeal in the companion congressional case on that very issue, but they actually set people for deposition, and those were later canceled based on the events that happened and the appeals that are going on, but that's exactly what they want to do. I'd like to respond also to the claim that these were different claims. These are, you can look at the complaint, which is in our appendix, and you can look at your opinions. They're precisely the same claims, and what their argument is that they're different because now they're going to present more evidence. But let me also clarify that it really doesn't matter for purposes of prohibition whether they're the same claims or not. They could have filed claims based on the 26 districts that they did not contest in apportionment 2. That still would be prohibited because it's still within the jurisdiction of this court to determine those issues, and they should have brought those claims in apportionment 1, really, which this court said you can't now bring new claims even in apportionment 2. You bring them all at once, and that's the constitutional design. That's why the Constitution provides for all adversary parties to be heard in that proceeding, and that's why you issued an order saying all interested parties, file your comments, file your brief, whoever wants to come. That's what it's designed to do. This is once and for all. We're only going to do this once every 10 years. We're not going to do this once every 2 years. We're not going to do this for the first redistricting after the census and then now go on and carry on your trial court actions.
You're out of time if you could sum up.
Yes, Your Honor. In conclusion, then, I ask that this court issue a writ of prohibition and hold that this court's decisions in apportionment 1 and apportionment 2 decided all claims that could have been decided under Article 3, Section 16 and Article 3, Section 21. Thank you very much.
Thank you for your arguments. The next case for the day is the Florida Bar versus McNamara. You may proceed.
Good morning, Chief Justice Polson, Justices of the Supreme Court, Mr. McNamara, Mr. Josephsberg. If it please the Court, my name is Jennifer Falcone Moore, and I'm here today representing the Florida Bar in the case of the Florida Bar versus Peter McNamara. At the outset, let me start by saying the Bar recognizes it carries a heavy burden in this case. We are asking you to overturn factual findings made by the referee in this matter. However, in this case, the Florida Bar can meet that burden over and above. There was overwhelming evidence that the respondent in this case never sent any document to the IRS.
Well, what's strange about that is the IRS, if no return was filed, how come the IRS sent a refund?
And, Your Honor, that's the big red herring in this case, and that actually is really important for several factors that go into play with the Florida Bar's argument here, and I'm glad that you raised it right up from the offset. The respondent asserts that the fact that a refund check was issued at all is conclusive proof that he sent a refund to the IRS. That cannot be the case in any way, shape, or form, and I will tell you why. If you look at the exhibits, which I know you probably don't have in front of you there, but the exhibits show you conclusively that that was not the case. The only document that the respondent ever submitted to the IRS, that the IRS acknowledges receiving, that everybody agrees was sent, was a request for extension of time to file the tax return in September of 2004. That document lists the estate representative as Marjorie Earl. That's the name that's on the certificate. That is not the estate representative's actual name.
Well, what triggered the refund?
What triggered the refund is the IRS has a check, and they had not yet processed the refund that successor counsel filed in 2007. So they've got a check. They don't have anything showing any taxes due, so they send it back. That's clearly, it was a mistake.
Where's the evidence on that? Is there evidence at trial?
Yes, Your Honor. There was
From what?
evidence in trial from Mr. Gordon. Mr. Gordon testified specifically that he spoke with the IRS, that they confirmed to him that it was a mistake, and then there are several documentary exhibits.
Whoa. It may have been a mistake, but I mean, how can you get in evidence from the IRS through Mr. Gordon?
Well, hearsay is admissible as substantive evidence in our case, Your Honor. because this is a Florida
But
bar
again,
proceeding.
coming back to the same proposition, I mean, how can you get in evidence from the IRS that that's what it is? Is that because I read all of this, and it doesn't seem as though that the IRS is saying that Mr. McNamara did not file it. It's just that they don't have records and stuff, and that if we go by that, I mean, they don't have half the records, is what it looks like here. Is that what 20 pages? When they ought to have, I don't know how many, but I mean, it looks like it's just a mess in dealing with the IRS. So I don't know how you can say that the IRS conclusively establishes anything in this case.
You're right. The IRS not receiving the documents is just one factor in a whole series of factors that demonstrate he never sent anything to the IRS.
But it doesn't, the referee makes also a credibility determination, which is that although the respondent told the bar he had originally filed it and was sending a duplicate, which is not true, and that's not good, and that's a violation, he said he filed it. That is in December of 2005. So, and you've already admitted you have a heavy burden. We got the IRS not having half the documents, and somebody, a lawyer who has never had a prior complaint stating under oath that this was done in December of 2005, you would have to show that this respondent actually fabricated this. I mean, if he was going to fabricate, he might as well fabricated the original document. You know, that's for you to disprove it. You've got to prove that he never, ever filed anything with the IRS. And I don't know how you do that without having gotten the IRS and their records and said, you know, for them to be able to verify that no income tax return was ever received by them from Mr. McNamara.
Well, we did have that, Your Honor. Mr. Gordon testified that as late as just before his testimony at the final hearing in this cause, he had called the IRS, and they still had not ever found or received anything from the respondent.
Again,
on
it
that
goes
point.
back to a dysfunctional unit is what it sounds like for these estate tax returns.
Without a doubt, the IRS, I'll use Your Honor's language, is a dysfunctional unit
I mean,
in that
doesn't
sense.
I was surprised to read what was here. Isn't really what we have is that, and I appreciate the argument that you have to make, but it seems to me is that what we have is that because he admitted, as I understand it, ultimately, that nothing was filed until December. That's been admitted. That's what you have. That's what this case is about. And again, I mean, it's not nice, but it's not to the extent that the bar is going on this case. It doesn't seem to me is that the proof is in the materials that I have read to that same extent. That's what I'm saying. And I hear your arguments, and I understand you have to make those arguments. But at the same time, I mean, we have to separate argument from what we see in the record.
Absolutely, Your Honor.
Yeah.
And I'm asking you to look at the documents that are in the record to support the argument that I'm making to you now. If you read the statements that he made to the Florida bar in this matter, it's not just, oh, I filed it on this date, I filed it on that date, and then at trial, oops, I said the wrong date. He goes meticulously into detail. He talks about how he properly filed, how he timely filed, how he handled it in a professional manner, how the IRS did this or this or this based on what he sent. He's not just making a statement, I filed it on this date or I sent it on this date. He's actually going into great detail to support the idea he sent it not only in December of 2005, but in October of 2005
So you're saying
and
that
again
he
in March.
was attempting to cover up that he had not filed it earlier.
Absolutely.
That's what you're saying. So it comes back to that at least by December that it was filed, and that's what, isn't that what we're going with in this case?
No, Your Honor. We do not at all concede that anything was filed
Well, I know
in
you don't
December.
concede anything. I'm trying to get to what the record shows.
I understand.
And not just argument of counsel. That's all I'm trying to do.
If Your Honor will give me just a little bit of latitude.
I'll give you total latitude.
It's not just that the IRS didn't receive it. We also have the fact that the state authorities didn't receive it, the Florida Department of Revenue. He says in two different written pleadings or 2 written responses, one to the Florida Bar, one to the malpractice attorney, that he sent the same federal tax return to the Florida Department of Revenue.
Did you make this argument to the referee?
I did.
Just because we have such limited time, and you've said it out in your brief, what I'm more concerned about is the sanction.
Okay.
The referee recommended probation. The bar is seeking disbarment. There seems to be a real disconnect here. Now, if I'm understanding this correctly, and this is not a good thing that Mr. McNamara did. It appears that he dropped the ball and either never picked it up or picked it up in December. And then when the bar asked him about it, he was untruthful.
Yes.
And is there any evidence that there was a selfish motive in what Mr. McNamara did as opposed to a royal screw-up? That is, that he missed it, that's a really bad thing or it could have been a really bad thing. What is it that the bar is going on that would demand disbarment in this case?
Your Honor, this is truly a case of the cover-up is worse than the crime. This would have been a simple case of neglect with a very minimal sanction if, in fact, he had owned up to the mistake in the first place. We know there's a dishonest motive here, even if you accept his testimony that
So this
he
is sort
actually...
of like a Watergate for the bar?
Yes, Your Honor. Even if you accept his testimony that he sent the document in December of 2005 for the first time, which is what his testimony was on the stand, it's clear his intent was to either protect his reputation, to cover up his mistake. That is dishonest, and that is a selfish motive. It goes to his motive to protect
Is this
himself
the
at the expense of the
document-
truth.
The document in December is the one that had duplicate on it?
Yes, Your Honor. When he
And-
sent it to the
And he
IRS.
has agreed that that was false, that it really was the first time that he had sent the IRS this document.
Yes, and after
so-
many years of litigation, that's the first time he said that was the first time he sent it to the IRS.
Okay. When was this document in relationship to when the bar began to look into it? I'm trying to figure out if he did this document because the bar had begun to investigate him, or whether or not he was doing this because his client was on, whatever. So when was the bar complaint, or when did the bar first get in touch with him in relationship to this?
The bar complaint is long after it. It would not have been generated directly as a result of the bar complaint, although he used it in the bar complaint to establish that he sent something to the IRS. We're suggesting that's fabricated. However, Your Honor is directly on point with your question, because the evidence shows that he at least created this document at one time on his computer the day before he sent it to Successor Counsel. Successor Counsel gets in the case in November of 2006, immediately starts requesting Mr. McNamara's file, requests it over and over and over again. At least 2 months go by before respondent hands the file over to Successor Counsel, and the evidence shows that at least his computer shows that he created the December document that he sent to the IRS the day that he mailed, or the day before he mailed it.
The referee found contrary, and I don't want to use words like metadata, I mean, because I'll be,
Thank
but
you, Your
as
Honor.
I understand it, when you reopen a document that's stored on your computer, it may give a different date and not necessarily the creation date. And I thought there was testimony on
experts
that.
canceled each other
In
out.
fairness, again, if he had never filed and lied to the IRS, I think we would be dealing, but let's just assume the referee's findings are there. You're still saying the bar considers this to be a disbarment, and I'm surprised to hear that. So again, give me your best argument about why, for a respondent that had no prior history, that this occurred in 2004 and 5. We're now in 8 years later. This demands that this respondent never be able to practice law in Florida again.
Absolutely, Your Honor. And the very short answer to that question is because he simply is not trustworthy, and we cannot trust him to do the right thing, to
Boy, if
own up to
every-
his mistakes.
But the bar has never, if every lawyer who comes before the bar who isn't forthcoming if the bar said we need to disbar those lawyers, we'd have another few thousand, on the hook. I mean, I don't want to say that and there are some of my colleagues that would think that's a good thing. I just don't think our precedent supports that that the act of misrepresenting something itself will be grounds for automatic disbarment. And we'd be going up another, we'd ratchet it up, and maybe that this is the case to do it in, and that's what you're saying, is that this dishonesty is of the nature that we can't trust this respondent.
That's true, Your Honor, but you actually do have case law that supports my position in this case. You've said over and over again that fundamental dishonesty is just something that cannot be tolerated by a profession that depends on the truthfulness of its members. However, in Cox, 794 Southern 2nd, 1278, you said that disbarment is the presumptive sanction for an attorney knowingly presenting false testimony in a judicial proceeding. Here, the bar proceeding is a judicial proceeding. He made numerous misrepresentations, not just once, not just twice, many, many times. His story changed over and over and over again, depending on who he was talking to and what concern he was attempting to relieve. And I'll go through each instance of that to demonstrate to that to your
You are
honors.
deep in your rebuttal.
I'm sorry?
You only have about a minute left in rebuttal.
Okay, really quick. Florida Bar versus Orta, each individual instance of dishonesty is a separate offense, and cumulative misconduct is treated more severely. Senton, lying in a disciplinary proceeding alone is grounds for disbarment. You have the case law, essentially the aggravating factors as well that are present in this case, the numerous instances of dishonesty. Those types of things demand that in this case, it's different than an isolated act of, oh, I made a mistake, oh, I made a misrepresentation about the day that I sent this to the bar or to the IRS. This is over and over and over again to numerous people, to a court of law, in a disciplinary proceeding, to his client. And the judge found all of that as intentionally misleading all of those parties. Thank you, Your Honors.
Good morning. May it please the court. My name is Bob Josephsberg. I'm here on behalf of Peter McNamara. But I'd like to digress before I even start. I also would like to defend Ms. Falcone Moore, who I have learned to really like during the last 2 years. There is a disparity here, which Justice Pariente refers to, where the bar is asking for disbarment, and we're talking about 2 years probation. And in the beginning, I used to think that this was just ridiculous, that it was incredulous she could take a position like that.
But it seems to me that what she's really saying here is that while your client may have made a mistake and not filed what he was supposed to do for this estate, to cover that up, he did one dishonest thing after the other. And so that is what I understand is her reason why disbarment should be the proper sanction in this case.
That is part of it. The other part of it is that in her heart of hearts, and the bar's heart of hearts, which is a good heart, they believe he never filed it. And they believe he fabricated on his computer. But the facts are, as the referee found, and you are bound by, unless there's no proof of it, that the computer was not fabricated. We had an expert who said that's not what happened. And we had all sorts of testimony, not just what Chief Justice Polston said about the refund. We have letters from the IRS in October 2004 and on December 5th, 2005, and December 5th, 2005, saying you haven't filed your return. And then after we file this on December 16th, those letters cease. No more letters after he files this on December 16th. We have all of this proof, but the bar does not accept it. I want you to know that I agree. If he didn't file this, and if he jimmied his computer, and if the referee found that, he deserves disbarment. But the bar will not concede that if he didn't do any of those things, that he deserves probation. It's because they can't concede that he didn't do those things.
A question on this refund. What does the record establish as to when the refund check was issued?
The refund check was issued along with the return. The return that the other lawyer filed took 6 weeks to reach the right place in IRS. The check was immediately cashed, and the IRS records, including their transcript record, showed no tax due.
Wait, so the refund, which was $65,643, was the amount that, when Mr. Gordon filed the tax return, stated was actually due to
Yes.
and so they sent a check.
And they sent it to us. because they
No,
had-
I'm asking, when the tax return by Gordon, the supplemental tax, the actual tax return that that we know was filed, that was signed, filed by the successor attorney, that return showed that there was an amount that the estate owed. Isn't
Yes.
that correct?
Yes.
Owed, not due, owed.
Owed $65,000.
Wait, I'm sorry. It was that the estate owed it to the IRS.
Yes.
Of $65,006. Did they then, with the return, send the check? Did Mr. Gordon
Mr. Gordon sent the return and the check.
and the check?
IRS separated them. Took 6 weeks to process
But
the return.
I guess I'm.
They immediately cashed the check.
I don't know how the fact that they sent a check back in the exact same amount that was reflected due in the subsequent return is evidence that Mr. McNamara filed something back in December of 2005.
Because the IRS transcript shows no tax due. And the reason it shows no tax due is because they received his return on December 16th, 2005, showing there was no tax due. And their
So they were
transcript
just
shows.
returning back a check. They were saying, no, your interpretation of that and the referees was that confirmed that the IRS didn't think there was tax due.
Correct.
But
And-
subsequently, they realized there was tax due.
Yes.
Which is-
When they got that return, they understood there was a difference. But we're not here to discuss the
I
difference.
see. So they returned the check that was separated because they had, your hypothesis or the inference is that they had the prior return showing nothing was due.
Correct, based upon IRS expertise
Gotcha.
from both my
Now-
client and from Professor Sam Ullman.
Now, as much as I'm not sure whether this is a disbarment case, I don't see how this is a probation case. Here is somebody that he lied, bald-faced lied to the bar repeatedly. He only came clean in saying, I filed the December, I filed this, but it wasn't a signed return, it wasn't a duplicate, when he finally testified before the referee, which I assume may have had something to do with his counsel, saying you better play it straight. So we've got no question that he lied to the bar. Is that correct? He lied to the bar.
Not totally correct, if I can just guilty with an explanation.
And also, while
there are
you're
things in his letter
explaining
that are
also
wrong.
that he lied to when he filed in the probate court that the tax return, he needed an extension of time to file because of issues with the IRS.
His letter to the probate court had one error. He said we filed the return, it should have said we sent the return. But it had no effect upon, it kept the estate open. It had no benefit, no effect when he said things are not resolved, and things were not resolved. When he said it was filed, apparently in IRS language, filed means it was signed by the taxpayer. It was only sent since it wasn't filed by them. And at
Could you
trial,
explain? I don't understand that record reflects. How would somebody send a return that's not signed? I don't understand a lawyer sending the IRS unsigned return. It's because it's not valid. I mean, you might as well send them nothing. I'm just trying to grasp if the record reflects. Was that an oversight or was it an intentional act to send it unsigned?
it was an intentional act because the client, he testified, would not sign, just didn't come. He wanted to get it done, and he filed it, and they accepted it. Even though, he didn't file it, he sent it, and they accepted it, even though it wasn't signed. It was
How do we know
wrong,
that, how do we know they accepted it?
because they never returned it, they never questioned it, and their
How do we know
transcript
they
showed.
got it?
Is that part of the problem? No, we don't.
Well,
Maybe you can infer they got it, but
well, for two reasons. One, they stopped sending letters saying, you haven't filed.
did they give you were they able to produce a copy of it?
No, there were 21 documents out of 53. They couldn't produce.
Are those letters computer generated?
Yes,
They wouldn't send a personal letter.
no, but the computer knows that they received a return, so it stopped sending the letters. And his letters to the bar weren't the first time that he admitted that it was just, one time he filed. In the letter to the bar, and the letters to the bar aren't just, that's why I took some issue with you're saying that they're just plain lies. His letters to the bar, which the bar says alleges as deception and misleading, I wouldn't use those terms. I would say they were woefully inadequate, poorly drafted, inconsistent, sloppy, and wrong. Now, part of Exhibit 32...
And wrong?
And wrong. Wrong. In that he does say in them that it may be the second or it may be the third, but his phraseology is very interesting.
When you say wrong, that's incorrect and a lie. That's what, is that
To me,
what
a lie-
wrong means?
To me, a lie, most of the time when people lie, they know it's untrue, and they are misstating the truth for their benefit. In his letter
And
to
so
the bar...
what does wrong mean?
In his letter to the bar, he said, unaware she had not signed the documents, it would appear that I inadvertently mailed the unsigned estate tax returns to the IRS. He later in that same letter, where he had in prior letters said it would be the second, the third, duplicate return, et cetera.
But wait a minute, you just said, in the letter, he says, I inadvertently sent this unsigned thing. But I thought you said earlier that it was intentionally sent knowing that it was unsigned.
Yes, there's disparity between his letter to the bar 3 years earlier and his testimony at trial, and in that very letter where he referred to that, he later says, if the IRS had not received the original no tax estate return sent on December 16th, 2005, then the IRS would have followed up. In the very letter, which they say is misleading, he also says, the original one I sent was on December 16th, 2005. The letter is inconsistent. If his intent was to mislead, he wouldn't put in another paragraph saying that the original one was the one he filed on 2016, on December 15th.
It's difficult for a lawyer, though. I mean, as Justice Periente pointed out, this was a mess on his part, and in dealing with the IRS. Now, IRS certainly had issues of its own, it appears, and the whole situation with the estate filing is very garbled. But having said that, he's an officer of the court, and as a lawyer, he has a duty to respond truthfully, and that just did not happen here. So it is difficult, although I would think disbarment would be perhaps too harsh. I think just a probation would be too light. So is there some other kind of discipline you think would be appropriate other than a probation? Because to tell the bar and act in a way this lawyer did by making some misrepresentations that are just more than just inconsistent statements, it seems like more than a probation would be appropriate here.
Well, there are all sorts of things that are available between probation and disbarment. I had argued in the alternative for a 60-day suspension.
Yeah,
If
I'm
the
just
court-
not, it seems to me, based on our case law, that this case is more appropriate for a rehabilitative suspension. And I'd like you to address why that isn't under the circumstances of the findings that based on what the referee's findings, why a rehabilitative suspension for dishonesty based on dishonesty isn't the more appropriate sanction, because we can't have lawyers misrepresenting or being incomplete or running the bar around. We need, when the bar sends an inquiry because a client has gotten a runaround, that the lawyer takes it like as if it's the Supreme Court itself saying, you tell us what happened and you tell us now. And I consider that to be a very serious violation, and it frustrates what the bar tries to do. So why isn't a rehabilitative suspension appropriate?
Because the trier of fact who sat there and watched and listened felt that Mr. McNamara should not be suspended. I should explain to you that while the bar
But let's
says,
go on case law, because you know that we don't give the same deference to the sanctions as we do to the findings of fact.
Correct.
So give us the most similar case that would say, no, a non-rehabilitative suspension less than 90 days is appropriate as opposed to a rehabilitative suspension.
That's the 91.
they are the cases,
That's the 91.
Less than 91, right?
they are the cases that we list in the brief of Florida Bar versus Robinson and the Florida Bar versus Whitaker. And one thing that should be understood is while we've moved off of the argument whether the referee should have accepted his statement that he did file this, and is arguing that since the referee did not believe him regarding these three matters in which he did wrong, that the referee should ignore all of his testimony. That's not what a trier of fact does. A trier of fact, if you're wrong about some things, may consider that regarding the remainder of your testimony, but you're not bound by it. And what's fascinating about this is we had a hearing 15 months ago for 4 days, and Mr. McNamara looked the bar and the referee right in the eye, and the referee is a former prosecutor and a federal prosecutor. And he told them, I was confused. I thought I had filed this before. I certainly did file it on December 16th. The things that the referee found he did wrong were not at this hearing. They were things that had occurred 2 and 3 years earlier, when, in the anger of being fired, everything else happening, and the client had refused to sign the returns.
Was that a finding that the client had refused? Was there a finding on that the client
No
had?
finding, but that's what he testified to. And the referee agreed that he did file on December 16th. So what happened here is 2 or 3 years earlier, when the bar had first started writing to him about this, he put together 2 letters that are wrong, misleading, inconsistent, because elsewhere in it, it says the original one I filed was on December 15th of 2005. And the referee felt that he had learned his lesson. He had been put through all of this. He was honest with the referee. There was no harm done to the client. He had a perfect record for 36 years. He was a good member of the community with a good reputation, a good lawyer, and there was no harm done whatsoever. And that's why probation was appropriate. If the referee had said a 60-day rehabilitative suspension, I couldn't come up here and argue to you.
I mean, non-rehabilitative. 60 days would be you wouldn't.
Yes, but the problem is, in reality, if you have anything over 91 days, it's a 2-year suspension because you don't get back in for 2 years. And so I just get very chilled when I hear anything over 90 days. He showed himself to the referee to be a good person. He showed himself to be sorry for the things that he had done, that he hadn't filed it on time, that he was having trouble communicating with the client. All of these things occurred, and he then did the best he could. And there was no benefit to him whatsoever of anything he did that was wrong. He didn't do it for self-benefit or profit. If there are any other questions, otherwise, thank you very, very much.
Thank you for your arguments. You got about 20 seconds.
20 seconds, okay. First of all, the evidence does not establish that that the client refused to come in to sign. In fact, respondent himself said that when he got the December letter from the IRS, he simply said what he had on hand. He admitted on cross he never even called the client and asked her to come in and sign it, never tried to get in touch with her. The evidence also shows that the no tax due on the IRS account statement, our tax expert testified that's not what that meant at all. It had nothing to do with any return he may or may not have filed. His testimony is the only evidence that disputes that. The other thing that you need to know is the red herring in the case, the refund check. Marjorie Earl is the name on the check. The only document with Marjorie Earl on the name is the request for extension of time. The tax return he says he filed had Kathleen Earl, her true name. If it was based on that tax return, it would have had to go to Kathleen Earl, and it had her address. The check would have been mailed to her, not him.
Do they open files when the extension comes in?
Apparently they did.
Well, if that had the name on it, then that would
That's
explain.
the only thing that
Well, I mean, that would explain if that's, something comes into the office and then you get something else that generates it.
There is nothing else that has the name Marjorie Earl. Her name is Kathleen Earl. Thank you, Your Honors.
Thank you for your arguments. The court will be in recess for 10 minutes.
rise. Supreme Court of Florida is now in session. Please be seated.
Our next case for the day is Victorino versus State of Florida. You may proceed.
Your Honors, may it please the Court, I am Chris Anderson, counsel for the appellant and defendant Troy Victorino. I would like to start out, given my choice, talking about Cannon's shutdown. That's issue number 2 in my brief. And just to focus the Court's attention, Cannon is the individual that...
If you could keep your voice up, please, so
I'm
we
sorry.
can hear you.
Is that better?
Yes.
Okay. Cannon is the individual that testified that Troy Victorino intimidated and compelled the other defendants into committing the murders. And then he shut down, refused to answer any cross-examination questions. And unfortunately, Mr. Victorino's trial lawyer failed to move for a mistrial, failed to point out to the court that Cannon's shutdown and refusal to answer cross-examination questions amounted to a fatal violation of Victorino's Sixth Amendment rights to confront adverse witnesses.
Is this an error that is, assuming that it was error not to object or make some kind of motion at that point? Is this something that is a fundamental error, or is it subject to a harmless error analysis?
It is not subject to a harmless error analysis, and it was also fundamental.
And what case law says that?
Davis versus Alaska and U.S. versus Chronic. U.S. versus Chronic states that where there's been a breakdown in the adversarial system, then there's per se ineffective assistance of counsel. And U.S. versus the Chronic case also cites and incorporates the ruling of Davis versus Alaska. And the United States Supreme Court in Davis versus Alaska ruled that where that right to confront adverse witnesses is impaired, even if some cross-examination of an adverse witness occurs, but not full cross-examination, then the trial itself is hopelessly flawed. The adversarial testing that is afforded by cross-examination and guaranteed by the Sixth Amendment did not occur, and the whole trial is invalid. So there is no harmless...
So you think Davis stands for the proposition that this is fundamental error and not subject to harmless error now? Is that what you're saying?
Both, yes. Yes, Your Honor, I do. Yes. And the reason is clear. The court in Davis versus Alaska stated specifically that when this type of breakdown in the adversarial process, this type of impairment of the right of cross-examination occurs, the courts are not to scour the record in search of some indicia of reliability. There is absolutely no court substitute for the truth-ferreting qualities of cross-examination. And Mr. Victorino was denied it. And just like in the Davis versus Alaska case, there was some questioning of Cannon that did occur, but not enough. Not enough to reveal his weaknesses.
It just seems to me, I recall that there's a Supreme Court case law that does in fact say that this kind of situation is subject to a harmless error analysis. And if that is the case, then in order to look at this in perspective, tell me what about Mr. Cannon's testimony that was so important to the state's case, and this was the testimony on any point that Mr. Cannon talked about?
The real deadly part of Cannon's testimony against Victorino was his testimony that Victorino made Cannon and the other co-defendants commit the crimes, that Victorino was the ringleader, when in fact there's ample evidence that that is not true.
And you're saying then that no one else in this trial talked about Mr. Victorino intimidating everyone and people believing that he would do something to them if they did not participate with him in these 6 murders?
No, not to the degree that Cannon did. And if I might just take a moment, it's a tremendous record, and I have had to make some lists. I hate having to refer to notes. But cross-examination of Cannon, if it had occurred, would have revealed, number one, that Cannon himself saw and participated in the killing of at least one occupant.
I'm sorry, your voice is dropping again.
Cross-examination of Cannon, had it occurred, would have produced testimony that Cannon himself saw and participated in the baseball bat bludgeoning of at least one of the victims. We know this because we have that information from the testimony of Cannon and Salas. If Cannon had been examined, it would have revealed that Cannon's claim that he was bullied and coerced by Victorino was nonsense, because Cannon himself was the only person with an automobile. Cannon had the only person with a transportation needed to drive away.
Well, but that's a non sequitur. The suggestion that because someone possesses the automobile that he can't be subjected to bullying and fear what somebody who doesn't have an automobile could do to him seems to me to be not reasonable.
Well, Justice Kennedy, in trial, the way this would play out would be as follows. Well, gee, Mr. Cannon, you're the only person with a car. In fact, you drove to and from the scene. Why didn't you just drive away? Gee, Mr. Cannon, you're the only person...
He was afraid of him. And apparently with quite good reason.
I'm just... And the only answer I can give you, Justice Kennedy, is that a jury would have a right to consider the fact that Cannon was the only person with a gun and the only person with a car.
Let me ask you about this. And when we look at what happened here in context and the fact that Mr. Cannon did not cooperate, at the point where he was not going to cooperate, isn't the correct thing that should have happened is that his testimony should have been stricken and a curative instruction should have been given, and then we move on. But when you look at this particular thing in the context of this whole case, the notion that this would have required a mistrial seems to me to be a stretch. It's going to be the law about when a mistrial is appropriate beyond what. So I'm sure you don't agree, but so tell me why that's wrong.
Well, the U.S. Supreme Court doesn't agree, Your Honor. The U.S. Supreme Court held in Davis versus Alaska that you don't engage in a harmless error analysis.
Well, but wait, they also said, they clarified in Delaware versus Van Arsdale, did they not, that read properly, Davis does not support an automatic reversal rule.
Yes,
they
sir.
Say that?
And let me clarify why. Okay.
You're going to clarify their clarification.
Yes, sir.
Okay.
Exactly. Davis, the court in Davis said, you have to look at what information would have been brought out in cross-examination and answer the question, was that information, was interrogating counsel, cross-examining counsel, able to bring out that information? And really, any relevant information or any information that impeaches a witness's credibility suffices. Now, it's conceivable that a witness may come to trial and not be impeached and have nothing of any significance whatsoever to the case. Or alternatively, answer other questions that make the unanswered questions duplicative, let's say. The information's already provided. But in Davis versus Alaska, that's not what happened. In Davis versus Alaska, that dealt with a burglary of a safe at the Polar Bar in Alaska. And a juvenile witness named Green testified that he saw the defendant Davis with a car pull out an object, appear to be hacking at it, and the car matched the one that was associated with the burglary of the bar. And then the trial judge said, well, you can't cross-examine this young person, Green, about their juvenile delinquency adjudication because that's supposed to be confidential. And that alone, just that limitation alone, vitiated the entire Davis versus Alaska trial because that dealt with credibility. It was relevant. So when you go into a chronic or a Davis versus Alaska analysis, you're not looking at harmless error. You're not looking at other means of validating or other indicia of trustworthiness. The only question the court asks is, was defense counsel unable to bring out relevant information from the witness? If so, the whole trial's gone.
But when you look at the Davis opinion, I mean, I think what you're reading out of it isn't exactly what they're talking about. In that case, the guys, not only was there no cross-examination, but what he had to say was so critical to the case. I mean, isn't that a factor that is taken into consideration there?
Absolutely, just as in Victorino's. First of all, no, it doesn't have to be critical to the case. It has to be relevant. Okay, but in Davis
maybe
versus,
the word isn't critical, but it certainly was in Davis a very important point that this witness was bringing out, and then there was no opportunity to cross-examine him, and I don't see that there was any other witness who had that gave us that information.
well, the information that was excluded by the trial court in Davis versus Alaska was information about the juvenile conviction.
But I'm talking about the information that he gave and then that was incriminatory against the defendant, that information. Don't you consider the nature of that information also?
Not really. In Davis versus Alaska, the court was not looking about what was given, the court was looking at what was not provided. And in Davis versus Alaska, defense counsel did a pretty good job in eliciting certain information about defense counsel, much like the Victorino case, was allowed to ask Green a number of questions about, well, weren't you concerned that you might be on trial? Weren't you concerned that the police dragged you down to police headquarters and interrogated you? Weren't you worried that maybe you were you could have gotten in trouble? Defense counsel did bring out some good information, good impeachment information against Green, but one very relevant piece, the juvenile conviction and the juvenile probation, he was not allowed to bring out.
Okay, let's assume that you should have, that there should be a harmless error analysis done here. You just tell me why, whatever Mr. Cannon said, why that information is so critical that it can't be harmless.
All right. Yes, Your Honor. And even though my position is
I understand your
prejudice, harmless error,
position, but I want you to tell me why it's so critical that it's not.
Okay. It was critical because we see from the jury verdicts that the jury gave one defendant nothing but life recommendations, and one of the defendants got nothing but a life sentence. And we also see it's really critical to the life versus death decision. in particular. We see, for example, that in Victorino's case, the jury recommended death by a vote of 10-2 for Aaron Belanger's, Belanger's murder. Okay. So in other words, with her death, Victorino came within just 4 jury votes of getting life. With Robert Gonzalez, Victorino came within just 3 jury votes of getting life. With victims Nathan and Vega, Victorino did get a life recommendation. With regard to victim Gleason, Victorino came within just 1 jury vote of getting a life. And with regard to Francisco Io Roman, Victorino came within just 4 jury votes of getting life. And so what is, if defense counsel had been able to properly cross-examine Cannon, they would have seen that Victorino was being framed as a ringleader. This was not a mastermind ringleader type situation.
Now, in this case, Victorino and Hunter were the 2 people who had squatted basically in this lady's house, correct?
Incorrect.
Victorino, that's not correct?
No,
Who
Your Honor,
was
it's
in the
not.
house?
They had a key to the Providence house that they got kicked out of. Okay, they were. If you look at all the and it's in your other opinions on the other cases. Essentially, Victorino and Hunter and others were flopping in houses that they had permission to be in.
Okay, they were flopping.
They were flopping.
In the
Yes.
house. Okay.
Crashing, flopping.
And his property was property that was taken, and he wanted back.
Absolutely.
He's the one who went over to, was it the daughter's house? Someone who had some relationship with the house. Isn't Victorino the one who went over there?
Yes.
And are you then departing from the evidence that says he then talked to the other people and said he was going to go over there and take care of the situation, basically?
Not at first. And this is where Cannon hurt him, Your Honor. Victorino is not the wild card loose Cannon killer that he was made out to be. The first thing he did is he went to the police. He went to the police and said, "Can you help me get my property back?" And then the police said, "Well, make up a list. We'll get around to it. We'll try."
And he said, and what he said was, "I'll take care of it." Something to that, didn't he?
Absolutely.
Well,
But
that sounds kind of ominous.
after he first went to the police, Your Honor, so he didn't go straight out with guns blazing. He first.
He formulated a plan.
I've got a list, and if I may just go through it real quickly, I think I'll answer your questions. First of all, there's evidence that Victorino was not the ringleader. The incident that set things in motion was the beating that Salas and Cannon took at the bowling alley. We also know that Cannon was the driver at all the encounters.
Justice Labarga has a question.
Yes.
Victorino, wasn't he much older than the rest of these people?
Yes, he was.
Wasn't he? How old was he at the time?
Yeah, he was 27
And how old were the other kids?
18.
18. And wasn't Victorino about 6'7" tall?
Yes, Your Honor, and
Okay.
that is why he was
And he's not the
particularly
ringleader.
vulnerable. That made him vulnerable to being framed as the leader. Your Honor, he had, in the mitigation phase, it came out that he had only an average IQ. It came out that the PET scan revealed mental organic brain problems. The mitigation phase brought out that he had terrible childhood and mental disorders as a result of his upbringing. When somebody that is that old is hanging out with younger kids, it's not a sign that they're smart. It's not necessarily a sign that they're smart. It could be a sign that he's very immature and he gets along with younger people. But continuing with the list, because it's important to this
You are
point.
deep in your rebuttal time.
Oh, I'm into it? Well, I better talk fast then. I'll go into my rebuttal time. Cannon was the only person with a gun. Even though Victorino talked about being so angry he could kill people, a lot of folks say that and they don't mean it. He was furious about his property being taken. Hunter was the guy with the switchblade knife. Even Salas admitted that he thought that Victorino just wanted to rough people up, didn't want to kill anybody. That's at page 3502 to 3 of the trial transcripts.
So he went in to rough up people with a baseball bat.
That's what Salas thought. But I would argue that he went in with baseball bats to get his property back, and things went horribly wrong.
Didn't
That's
he
a
arm
better
everybody
perception.
with baseball bats?
I'm sorry, Your
I
Honor?
thought everybody was armed with baseball bats.
That was the testimony, yes, sir. Now,
Now,
Victorino
was there any other evidence, the things that you said came in that he couldn't rebut, were they covered by anybody else?
No, sir.
So this is non-cumulative testimony?
I don't see it. No.
You know,
I don't see it. I'm just telling you about some of the other things that show that Victorino was not the leader. And as for the things that Cannon said accused Victorino of being, which was the ringleader that compelled and forced everybody, intimidated everybody.
What was Cannon's motive for being the ring? Why would Cannon was not one of those who was flopping, as you said, right? So what was Cannon's motive for doing all of this if he is the ringleader, as you suggest?
I'm not suggesting that Cannon was ringleader. I'm suggesting that Victorino was not the ringleader.
Oh, I see.
Okay. This was a situation in which a bunch of people came
weren't
together.
they going to get Victorino's property?
What? I'm sorry.
Weren't they going to get his alleged property?
Yes, but
That's
they.
the reason they went in. So
but
somebody
also,
else was the ringleader to get his Xbox and all its clothes.
But also, Cannon and Graham wanted to go to the Telford house where the murders occurred to get even with the Abbey brothers, who they said beat them up at the bowling alley. So they were there to get their own personal revenge.
Your theory is everybody else framed Victorino as being the...
Absolutely. It's not my theory. It happened. He was framed as the ringleader, and that's what got him the death penalty. And he was particularly vulnerable to being framed because of his big size. He is the size of the character Joe Coffey in the movie of The Green Mile.
Your time has expired. Thank you for your
Thank you.
arguments.
May it please the court, I'm Ken Nunley. I represent the state of Florida in this proceeding. If the court has specific questions, I'll attempt to answer them. Otherwise, I would say that the trial court properly found that there was no ineffectiveness of counsel.
Well, let me ask you about that. If counsel had, once he realized that the canon was not going to answer questions, had objected and moved to strike the testimony under precedent, would that have been the appropriate remedy for the inability to cross-examine Cannon by the defendant?
I think a motion to strike would have been the appropriate response, and the fact that it can be cured by a motion to strike indicates it is not fundamental error and indicates it is not harmless.
Okay, so the
Or
issue,
is
so we
harmless,
would
I'm
go
sorry.
back to first deficiency, but you would focus on prejudice. Is that correct?
Yes, ma'am. There is absolutely no prejudice to Mr. Victorino in connection with this part of his case.
Well,
or any
now, we
other.
did, in our direct appeal, we did at least rely in part on Cannon's testimony. Is that correct? I mean, we said Cannon, a state witness, testified he and Salas went because they were afraid Victorino would kill them. If they did not, he further testified that he, Victorino, Hunter, and Salas entered the victim's home on the night of the murder armed with baseball bats. And
Yes, ma'am, and that's in Hunter. Of course, that's in the Hunter decision where the court talked about this.
Well, no, it's in I'm reading from the Victorino decision.
Same language as in Hunter, but.
Well, I mean,
but
I would
y'all-
assume they're similar
Y'all
facts.
talked about, well, yes, ma'am, y'all talked about this in connection with this very issue in Hunter. And Jerome Hunter's decision is really Hunter got here first, and the Hunter decision is the one that is cited to by this court in the Victorino case as why this claim on direct appeal was denied.
I guess what I'm thinking is that when you said that, yes, it would be subject to be stricken and then a curative instruction given, I don't know how that equates with that, therefore it must be harmless, because if a jury is considering the testimony, as they did in this trial, but it's a difference. I mean, if a judge says, no, do not consider it, and do not consider it in your deliberations on guilt or in the penalty phase, then I don't see how that would be a harmless error analysis. Now, I agree that it doesn't most likely rise to the level of undermining confidence in the outcome, which is what we have to look at on Strickland, but I'm having trouble thinking that it just would be, well, it didn't matter that the defense attorney didn't object and that the Canon's testimony was stricken and that the jury didn't get a curative instruction. That just didn't matter.
Conceptually, we have several different standards kind of swirling around this claim. The first, and I guess the way to start is with the fundamental error component first. I think we all agree that it's not a fundamental error. If something is curable by granting a motion to strike and a curative instruction, then it's not fundamental error, which also means analytically that a harmless error analysis would be appropriate in the substantive claim context. We, however, have that third layer of Strickland that folds in on top of all of this, and while I'm not conceding deficient performance, the prejudice component of Strickland is the easier, more straightforward analysis for this court to conduct in this case, because we know that what Canon said came in through a number of other sources throughout the course of this multi-week, multi-witness trial.
Well, what about the aspect of, as I understand it, he's saying one of the things that could have been brought out if there had been proper cross-examination was the fact that Mr. Cannon actually, I guess, participated by hitting or killing one of the victims also, and that didn't come out in any other testimony. I believe that's what he was trying to say, that the defense attorney could have brought out Mr. Cannon's actual participation in this murder, and that is something that wasn't subject to someone else bringing it out.
If no one else brought it out and Mr. Cannon didn't say it, then it's not in the record. And I don't know where, I don't know where that's coming from.
But the whole point was that if he could have put that in there, the jury may have made a different credibility determination about Mr. Cannon if they understood his participation in the murders.
Well, then that should have been brought out in the post-conviction hearing as part of the ineffectiveness presentation, and it wasn't. Right now, we're left to speculate about what Mr. Cannon might or might not have said, and it's not in the record. I'm trying to argue in a vacuum. I'm having to being forced into arguing in a vacuum, not by you, Justice Quince, but I don't know how to respond to that other than saying we had an evidentiary hearing, and that's the time to prove up your claims of ineffectiveness of counsel, and there is no showing that Mr. Cannon could have presented something that did not come in through other witnesses.
But that's, I mean, it's tantamount to saying is that in the post-conviction arena, that if a witness simply refuses answer cross-examination, and you must assume that they're not going to answer any more questions about anything, that it escapes review. I mean, I hear your argument that we don't know what that cross-examination would have revealed That's what your argument is. And that's what you're saying, but, isn't that the practical effect then? So then witnesses could testify. I mean, every witness could get up, testify, direct examination, not do any, just refuse to answer cross, and if it's not stricken, you come down to, that's what I'm saying is that your argument produces the effect of you cannot review this.
Well, but we also don't reverse cases based on speculation.
Well, no, I understand.
And
That leads though to that. I'm not disagreeing with what you're saying. I'm just saying, what is the alternative? It's just it escapes review then.
The global result, I don't know. I'm arguing a particular case.
I understand.
And I know,
no, in this case, so he doesn't testify at the post-conviction. You never know what this cross-examination would have been. That's theoretically where we are.
Well, but in this case, we have other evidence from other sources that were absolutely subject to cross-examination, no question about that, who described what went on in this particular murder.
Including Connor's involvement?
Yes, including Cannon's involvement. But at the end of the day, maybe I'm kind of jumping to the end, and I would suggest for this court's purposes, the harmless error analysis.
Prejudice.
Prejudice, and harmless error, and I know Justice Kennedy last month we were talking about, I don't like to blend standards or talk about two standards in the same breath, but as far as prejudice is concerned, the prejudice from Cannon fell on the state, not on Mr. Victorino, because
isn't that a point here of if the problem with counsel's performance is that he did not do something that was going to undermine, that would cause the credibility of what Cannon had already said to be undermined in the eyes of the jury. It seems to me that when Cannon refuses to cooperate and starts answering questions, his credibility for that jury is kind of shot anyway.
That looks pretty incredible to me. And let's think about what Cannon said for a minute. He answers a few questions, and what he did is set out in the state's brief. And then he says, well, I'm not guilty. I'm not answering any more questions. I want to withdraw my plea. Judge Parsons, can I go home? That's what he starts saying. And I would suggest that the jury probably had him pretty well tuned out by then. Because certainly he sounded incredible at that point. And to find, if I could,
was there any, before you move, was there any suggestion that the state knew he was going to do this?
No, absolutely not. And Judge Parsons was very clear in his order that the state was as surprised or more surprised than were defense counsel. And in fact, any suggestion in this case or in this proceeding here that the state knew that was going to happen has been withdrawn. There is no such claim.
I just want to correct one thing that I cannot agree with you on, and I'm not sure if, you were blending things. The fact that this might not be fundamental error, which the court found it wasn't fundamental error, I think, on direct appeal,
right,
does not mean that it's harmless error. Because the problem is always that when a defense lawyer doesn't object to something that could have resulted, if the judge overruled the objection, would be subject to harmless error, now gets to fundamental, and then on post-conviction gets to prejudice, you never get a perfect situation where the defendant gets to recreate, well, if every objection had been made and the judge had overruled it, would they gotten a new trial? So we've got to be very clear that just because it's not fundamental error doesn't mean that it's harmless error. Do you agree with that?
They're two completely different things.
Okay.
There are two different things that this court does.
So we focused on the reason that it shouldn't undermine confidence is because what I'm understanding you're saying is Cannon wasn't a crucial witness for the state, and he is not the basis for the finding of guilt or the finding of any of the aggravators that subjected Mr.
No, ma'am.
Victorino to death.
He
Is
has
that's really how we need to make sure
Yes, ma'am, and
about
he
that.
has absolutely nothing to do with the penalty phase.
Because we certainly don't want, and I think what Justice Lewis says is this is important when we look at this, that for the state to put a witness on, and then a witness, even if it's a surprise, for that witness to feel that he is not going to be subject to cross-examination would be a very bad thing for criminal cases, for everybody. So we ought to be clear that the remedy, though, would be to move to strike and try to cure it. If it's critical witness, it may not be capable of being cured, and so it may require a mistrial, but that's not this situation.
That's not this case here, and the issue here is whether it was ineffectiveness on the part of counsel on the two prongs of Strickland to not move for a mistrial. That is the claim. It's not a claim of anything else. And in this case, because a motion for mistrial would have been properly denied, there is no prejudice for Strickland purposes. Again, I'm trying to be, we got to keep them in their little boxes, I suppose, but as far as the notion of who the ringleader was, I think this has been well hashed out on direct appeal. I don't know that I need to say anything more about it other than to say that witnesses other than Cannon are the ones who described how Mr. Victorino planned the assault on this house, how he assigned the various other defendants where they were to go in this house that looked more like a SWAT team's takedown of a drug house than what we normally see even in these most brutal cases that we talk about. And let's don't forget that Mr. Victorino is the one whose property was sought to be retrieved, and that Mr. Victorino is the one who kicked the door in, shattering the deadbolt and allowing Mr. Hunter to be the first one in the door to take out the first person closest to the door. Mr. Victorino was the ringleader in this case, and Mr. Victorino went to the extent of reserving certain victims for himself. This man was the ringleader, and the reason he got a death sentence is because he deserves it, not because of anything his trial attorneys failed to do.
And what you've just described comes into this record through witnesses other than Connor.
Absolutely. Mr. Cannon has nothing to do with any of that I just talked about. I would ask the court to affirm the denial of post-conviction relief.
Thank you for your arguments. The next case for our docket today is Foster versus State of Florida. You may proceed.
Good morning. May it please the court. My name is Terry Bakus. I'm representing Kevin Foster in the denial of his Rule 3.850 motion from the Circuit Court in Lee County. The thing in this case that makes it different from the mitigation ineffective assistance to counsel cases that you see every day is that the version of Mr. Foster's life that was portrayed to the jury was not remotely accurate. The information that was given to Mr. Foster's jury was that he had an idyllic upbringing, that he had a normal, stable home life, that everything was hearts and flowers, kittens, and trips to Europe. Nothing could have been further from the truth. And the reason that information was not presented was because defense counsel abdicated its duty to do a comprehensive mitigation investigation to the defendant's mother and to the 18-year-old client. The case law was legion in 1996. This was not the proper way to investigate a penalty phase case. This case was not one in which it was not under huge media scrutiny. It was a huge case in Fort Myers. There were 17 motions to change venue. That's how many changes of venue that were done trying to get the case moved out of Lee County because the media circus surrounding the case was so intense. Defense counsel was overwhelmed, and when he was overwhelmed, he abdicated his duty to Mrs. Foster, who was more than willing to spend all of her time giving lists of witnesses, lists of questions, access to any information that she screened and wanted them to know. So when they were coming to the time where they decided, okay, what is our penalty phase theory of defense going to be, Mrs. Foster insisted that there was nothing wrong with her son. And because defense counsel had no other information to rely on, because it had not done any comprehensive investigation into his family history, that was what they used. And when I talk about not doing a comprehensive investigation, I'm talking about not even investigating the paternal side of Mr. Foster's family, of his upbringing. His biological father was never even spoken with. The first time he spoke with defense counsel was when he attended the trial and walked up to the assistant public defender and said, "I'm Joe Bates Jr., and I think you should be asking these questions."
And to what extent did he have anything to do with Mr. Foster's life?
Mr. Bates was, first of all, he was a biological father, so he was around at the time that the birth problems occurred, and that was one of the mitigating factors that the defense wanted to present. So he had firsthand accounts of Kevin's difficult birth, the fact that he almost died several times.
Did anyone testify about that at all?
Mrs. Foster did give very cursory testimony about the fact that it was a premature birth and it was a difficult birth. But it was a few sentences. There were no medical records because trial counsel didn't even go to the Northwest Texas Hospital and gather the hospital records on the birth. So he didn't have those in his trial attorney files, which seemed like a most basic thing that you would do. What reason can you give for not going to the hospital on something you're going to use as a mitigating factor? There's no reason for not doing that. And even in the records that defense counsel gathered, it doesn't appear they even reviewed them. And I'm using as an example his school records that showed, despite the fact that Mr. Foster had a high intelligence, he flunked 5th grade. He had very, very unstable grade periods. In the 9th grade, by the time he got to the 9th and 10th grade, his grade point averages were 1.9.
And what was demonstrated on post-conviction that justifies these grades that you're talking about?
Well, the red flags were everywhere, as I said before.
I'm saying, on post-conviction,
yes.
How did you tie him having flunked the 5th grade, bad grades in whatever level he was in, with this crime?
Well, what those things did gave red flags that mental health evaluations were critical to see why those things happen. Because we're talking about an instance in which the mitigation that was presented at trial did not establish any nexus between his idyllic upbringing and why he got into the situation that he ended up in. There was no explanation whatsoever. So when we went in post-conviction, we did what trial counsel should have done. We gathered the records. We looked at the hospital records to see the apoxia, the encephalopathy that occurred at the time he was born. In the trial attorney's file, and this is at record page 1267, this is Mr. Foster's booking photo. If you look at the booking photo, you look at the shape of his head is asymmetrical. When any reasonable attorney sees that, the first red flag they see is to get a neurologist or a neuropsychological evaluation, someone to do some testing to find organic brain damage. That's what we did in post-conviction. That's what we presented. The Dr. Bordini.
Did that go unrebutted in post-conviction?
Yes, Dr. Gamache testified for the state. However, Dr. Gamache never evaluated Mr. Foster, never set eyes on him. He agreed with almost all portions of Dr. Bordini's tests, except the part of the test that showed that he had an impairment. He didn't have any problem with the other parts of the test. In the Wisconsin card sort, for example, Dr. Gamache keyed on that one, saying that Dr. Bordini didn't give the incomplete test, but what he also did not disclose is that the Wisconsin card sort test comes in 3 different versions: an abbreviated form, 64 cards, 120 cards, and in 200 cards. He never asked me, Dr. Gamache, which test did he give, and he never asked any questions, which I offered him any information possible that would help him with his evaluation. So his evaluation offered by the state was not competent. It wasn't competent under American Psychological Association standards, and it wasn't competent just by the records that you looked at that we presented in post-conviction. But let's go a step further. Let's say you're right, Your Honor. Let's take out Dr. Bordini because Dr. Gamache doesn't agree with that. Let's go to Dr. Sultan. Let's go to Dr. Hyde and their evaluations. Dr. Gamache was not able to refute what they had said. Dr. Sultan had spent hours evaluating and creating a social and life history for Mr. Foster that showed his entire lifetime, how chaotic it was, how he had 4 fathers in the space of 16 years, how he moved constantly, how the environment he was raised in was emotionally unstable, and how his organic deficits caused him to be emotionally immature and emotionally damaged to the extent that it affected his ability to have impulse control and other frontal lobe impairments this court is very familiar with. So that was the link that was missing. And this is not a case in which we have to speculate about the prejudice. The jury was very clear, and actually one of the most vocal juries that I've seen in a very long time. They said it. They said it to the media. They said, we were looking for something, and he didn't give us anything. It's because the defense attorney gave them nothing except the sanitized version of his life that Mrs. Foster wanted the defense to present and wanted to make her son look like there was nothing wrong with her son, that he came from a good family, and that he was loved. And she wanted to make sure that that was what the jury saw. But because trial counsel had not looked at anyone else, they hadn't even sent an investigator to Texas or Oklahoma where the family members lived to speak with them to find out what was the family like. Had they talked to the biological father, they would have learned what his mother was like, what his life was like.
Well, when the testimony of the investigator in the public defender's office said that the public defender's office pulled out all the stops in this case, what are you saying, that there is no evidence that they did anything in the case, or just that they were wrong to rely on the mother to give them information, which, I mean, we see, that's where you start with the mother, with the defendant. Why were they supposed to distrust what the mother had to say? They got the school records. So let me understand, are they just lying when they said they pulled out all the stops?
Well, I think Investigator Harsh, illustrated the fact that, and one of the problems in the case was that it was a platoon type of investigation. Each investigator had just a little piece of the case to investigate. And from her perspective, all she investigated was a timeline of the co-defendants driving back and forth from the crime scene, which was a guilt phase issue. And to her mind, they had pulled out all the stops. She saw a lot of activity. The problem is they weren't pulling out all the stops as far as getting mitigation investigation. That was the thing, that there was a dearth of information in the trial attorney files, which would be the place that would show you exactly what they did. And there was nothing there in any of the files about what they did to do an independent mitigation investigation outside what Mrs. Foster gave them. In their files was a list of witnesses that Mrs. Foster gave them. And if you look at and compare that list with the people who testified, all of those people were on that list. Each one of them had been spoken to by Mrs. Foster before defense counsel even spoke with them. Sometimes they met at the public defender's office. Sometimes they met at Mrs. Foster's house. And then we get to the paralegal / investigator who was the ex-con, Jamie Wooten. And Mr. Wooten was having a sexual relationship with Mrs. Foster during the trial, which it just underscores how the assistant public defender had lost positive control over his defense case. He had taken on the responsibility for essentially the entire case. According to co-counsel Renard, he was just a glorified sounding board for lead counsel. On the other side of the bench was the state attorney's office, who had 3 prosecutors assigned to the case working full-time. And so when it came time to do the penalty phase, they went with the easiest route possible, which was to take what Mrs. Foster had given them and go with it. But the red flags in their own files that they did happen to gather, the school records, the hospital records when Mr. Foster had 2 arguably suicide attempts in 24 months before this crime happened.
I thought the hospital records came in with regard to the gunshot.
The hospital records were referred to, yes. They were referred to.
Referred to only? They were not in evidence?
My understanding was that they were referred to, and I don't recall them being,
in going through the materials,
I trust you that they were.
Well, in going through the materials that I've looked at coming in this morning, that the indication in the medical records is that it was not self-inflicted, that it was an accident.
That's what the defendant kept telling people. But then
Well, I thought it's in the records. It was not in the records?
The gunshot wound was in the record. The second
As
suicide
being,
attempt wasn't.
With the medical records,
Yes.
did they indicate that it was an accident?
The medical records reported what Mr. Foster told them, which
Well-
it was not a suicide attempt. That's what he has
Okay,
always
that's all
said.
of the written documentation said it was not.
That's what he said.
Okay, well,
Well, it
I
went on.
understand, but I mean, that's what it said. So, I mean, the statements that, I mean, you weren't there, and so you're saying that it
No.
was. So, I mean, we have the records, there's evidence there.
Right. But then 3 days after he's released
he
from
went-
the hospital,
excuse me.
he jumps from a bridge.
He went beyond just saying it wasn't a suicide. The Lee County Memorial Hospital records, which are in the record, say, quote, "This is a 16-year-old white male who claims that while cleaning a .45 caliber revolver pistol and talking with his girlfriend on the phone, the gun accidentally went off, hitting him one time in the abdomen. The patient denied this was done on purpose. In conversation with family, the patient had no emotional problems or suicidal ideations." So it went beyond just him saying, no, I didn't mean to do this. He actually was he said he's talking to his girlfriend on the phone
He was talking
and
to his
cleaning a
girlfriend on
gun.
the phone.
Okay,
Yes.
so how do you
Yes.
get to suicide from that?
Well, first of all, the girlfriend he's talking to on the phone they're breaking up at the time they're talking together. Then 3 days after he's released from the hospital for this gunshot wound, he jumps off a bridge and contracts a severe staph infection. He, of course, is always saying, no, it's not a suicide attempt, but he is questioned extensively by law enforcement because they don't believe him. And when he is spoken with by mental health experts after the fact, the ones we had in post-conviction, kept readdressing this issue, and he finally later acknowledged, yes, he was having suicidal thoughts. And this goes back to not going into the family history. It leads back to that. And why would you suspect that? Like you said, why would you suspect anything other than that? Well, had they gone back and traced the family history, they would have found his history of depression and his manic episodes between depression and hyperactivity and the bipolar disorder that Dr. Sultan and Dr. Hyde saw indications that were present. This goes back to the organic brain problems and all of those other things. Yes, he denied that those were suicide attempts, but if you look at the broader picture, there were red flags there that that was not true. And those were the things that competent defense counsel would have ferreted out. That's what they would have looked at. And it wasn't a difficult task to send investigators to Texas and Oklahoma, because they did send an attorney.
Had he sent them to Oklahoma, they would have been able to prove that it was a suicide attempt?
No, I'm not saying that. I'm saying had they gone to Texas and Oklahoma, they would develop evidence that shows a history of depression and manic episodes that would give you pause to think, well, maybe I should have a mental health expert look at this and whether these were really suicide.
He denied it was suicide, right?
Yes, he denied it was
His
suicide.
mother denied it was suicide.
He denied he had any mental health
And
issues
his mother
whatsoever.
denied it also.
Which is not unusual. And co-counsel Renard also stated in his testimony, it's not unusual for defendants to deny that they have any mental health problems or to deny anything that's going to make them look weak.
But how would they have proven that it was suicide?
It's not necessarily proving it, it's the red flags that you need to investigate the issue further. And that's the issue, is that they didn't even look to see, okay, we have this evidence here that he shot himself. There are powder burns around the wound, which indicates that it was more than just twirling the gun around and playing. It means it was in close proximity to his skin. So that in and of itself, okay, he says it isn't a suicide attempt.
You are deep in your rebuttal time.
Yes, Your Honor. But 3 days later, then he jumps from a bridge. Isn't that an indication that, yes, it was a suicide attempt? What I'm saying is that these are the red flags that are anticipated in Rompilla v. Beard. Rompilla v. Beard talks about when you see these red flags, it's an indication that further investigation is necessary. Trial counsel didn't do it in this situation. Thank you.
May it please the court, Assistant Attorney General Stephen Ake on behalf of the state of Florida in this case. The trial judge correctly denied this ineffective assistance counsel claim. And in fact, evidence clearly refutes the whole premise of their argument that trial counsel deferred to the mother, Ruby Foster, in delegating their authority to investigate. That was entirely refuted at the evidentiary hearing.
Can you just address the fact that Foster sought to reopen the evidentiary hearing with the letter that Wooten, the investigator, wrote to Foster talking about their personal relationship, and he says some things including, we know who that one is. Remember, I was around on a daily basis. I know the truth, so do you. And concerns me that there is that there's no evidentiary development of what this meant and whether Wooten and his testimony about the investigation was somehow not true. So can you just address that concern as to whether the evidentiary hearing should have been or should be reopened just to ferret that out?
First off, Your Honor, the motion that counsel filed regarding that was not to reopen it to question Jamie Wooten, her witness at the evidentiary hearing. The motion simply was to reopen it to introduce this letter as evidence, which the trial court agreed to do and treated it as evidence. And then the trial court made a credibility finding in his order saying that he found Jamie Wooten's testimony credible at the post-conviction evidentiary hearing regarding what the PD's office did in their investigation. The part that he did not find credible was the part where Wooten denied having a relationship with Ruby Foster. That is in that letter. That's the thrust of that letter. the sentence that you read, the very next sentence, Mr. Wooten goes on to talk about Ruby Foster's own case that she had. It's not clear entirely who Mr. Wooten is
So
discussing
you're
there.
saying that that Ms. Bakus didn't seek the remedy of wanting to
No.
put Wooten back on the stand?
No,
to
Your Honor, if
question
you
him?
look at the motion, that is not included in there. It was simply, I want to reopen the case so I can introduce this into evidence and/or, I think the motion's even titled, and/or have this court treated as evidence, and that's what the judge did. As I was saying, their premise is Ruby Foster dictated everything that was done in this case, and that simply, surviving counsel, Mr. Renard, testified that that was not true.
I understand that's sort of what it sounds like, but, I mean, might have sounded like, but what I'm hearing Ms. Bakus say is that there were enough signs that there was something amiss with this young man who was only 18, that there should have been further mental health investigation and mitigation developed, that it was just the fact that he was just his normal kid going along in life, and then this happened. Just the indications were maybe that wasn't the case. And we all do know that, especially when there's still, before the death penalty is imposed, there's a psychological refusal sometimes to say, well, if there's been abuse or neglect, people don't necessarily want to be forthcoming. So I thought so take it from the fact that let's just assume I do agree with you that they didn't abdicate to Ruby Foster, but the question is was the investigation as thorough as it needed to be, considering, the facts of this case and the age of this defendant and the possibility that he might have had a history of depression or some other significant mitigation?
Well, a couple of things, Your Honor. First, they did a evaluation form where he denied having any depression or mental illnesses or any of that. They had two experts appointed immediately. I mean, the very first documents in the record on appeal and the direct appeal are the appointment of Drs. Wald and I forget the other doctor's name, the neuropsychologist that's in Dr. Wald's practice. But those experts examined Foster. Dr. Wald examined him for 2.5 hours, I believe it was, and also talked to Ruby Foster, the mother, for over an hour.
Do we have those reports in the record?
They did not do a written report. We have the billing statement was what was introduced. Dr. Wald testified at the post-conviction evidentiary hearing that he did not recall the evaluation and didn't prepare a report for Public Defender Jacobs.
Were their evaluations a competency evaluation, or were they also looking at
all-encompassing according to the appointment? It was all-encompassing for competency mitigation, whatever defense. It was a confidential expert appointed at the direction of the defense.
But when was it done? It was done right after you said they were
right
appointed?
After they were appointed to the case. It was one of the very first things they did.
And you said it was just a 2.5-hour evaluation? I guess what I'm saying, it doesn't sound like, it sounds like that would be more somebody even that was appointed just to determine competency to proceed. You don't have a written report? I mean,
they weren't obviously they weren't going to do one.
I mean, do we know?
Yes, they reviewed records. They have that in their billing statement that they reviewed records. They also have that they met with him for 2.5 hours.
But he doesn't even know, but he doesn't know what conclusion he came to.
Well, Mr. Jacobs passed away. He wasn't available to testify.
He, Dr. Wald.
Dr. Wald does not recall, no.
And has no records.
No, he had no records.
Would that be unusual if he had been employed to look at the mitigation case? Would that be an unusual
It was unusual
situation?
because he had retired from his practice, and there was something to do with his files that were taken over by somebody else. A hurricane had come through that area. It's just a matter of...
Oh, so you're not saying reports didn't exist. He just didn't have the records?
No, my understanding is I don't believe he did a report. I think he testified that it was not uncommon for him not to be specifically requested not to do a report and to just verbally...
And by the way, in fairness with Dr. Wald, we're talking about a 1996 trial.
Right.
We're talking about a 2001 post-conviction motion, and we're talking about a 10-year delay.
Right.
I don't know whose problem that
2011.
was in getting this to conclusion.
Right. It was a lengthy time period of 15 years, I think.
What was the reason for that?
There's probably a number of reasons, Your Honor. I know it began with, they did a motion to get rid of the judge and litigated that, a writ, I believe, up to this court on getting rid of the
But the
original
state
post-conviction
realizes the
judge.
state has a responsibility to get these
Oh,
cases.
yes, and we tried to move this case along, Your Honor, and there for a while, the judge that was on this case, he passed away.
Also, extensive litigation of a public record.
Definitely, Your Honor.
What was that about? A public record, so
There were just the usual getting the files from various agencies, the defense file and problems with that. That took a long time, but the real problem for a long time was the court was just not having hearings in a timely manner, in our view, and we did try to move it along. Eventually, a new judge came on and it moved.
we seem to get, at least the judicial system seems to get out of criticism are not moving these cases. But, once the state attorneys who prosecute the case, once they get the conviction and the death sentence, they kind of wipe their hands with it. And then it goes to you guys at the AG's office. So when you have a case sitting in a circuit where nothing's happening on it, I mean, unless the defense counsel is not going to move it, so unless the attorney general goes in and moves the case, it just sits there.
Well, we work with the state attorneys, and they try to move them too. And what happens is, in this case, is it was an old rule case. We didn't have the rule requiring periodic status hearings, but we would file motions to set a status conference. We need to do something. That did take place for quite a long time there during the public records stage of it, and I admit that it definitely is an unacceptable delay. But like I said, eventually we had a new judge come on, and the case moved very quickly once that took place.
So how long did Judge Anderson have it?
I believe Judge Voles came on to the case. I would say we had the evidentiary hearing in 2011. I believe he came on in maybe 08, 09, I believe. I'm not even sure. It might have even been later than that. I don't really remember the dates, Your Honor. I guess I want to go back to what trial counsel did. We know they had Dr. Wald, a mental health examination. Co-counsel Renard, who was second chair, testified, Dr. Wald didn't give us anything. There was no reason to go seek out other mental health investigation. They talk about what they brought forth in post-conviction as to brain damage and bipolar, but Dr. Gamache for the state refuted that evidence. And the whole idea that this defendant with his 137 IQ, verbal IQ, has brain damage and has impulse control was refuted by Dr. Gamache's testimony and the facts of this case. This was the leader of the gang in this case, and he's the one that planned this murder.
What did they actually review? I know there were 3 state experts that testified. Did either of the 3 actually examine Mr. Foster?
No, Your Honor, and Dr. Wald examined him at the time, but couldn't recall anything. He did examine him, but that was prior to trial. That was a long time ago. Dr. Gamache did not examine
and wasn't there another doctor?
There was another doctor for a very limited purpose of kind of going against Dr. Gurr's brain map thing. This was an issue with this brain map that Dr. Gurr had created. And that was the purpose of calling him. But that was the extent of that testimony? That was the extent of his testimony, was to basically go into Dr. Gurr's qualifications for that brain mapping.
I mean, nothing really changes the fact that this defendant was the person that was the head of this Lords of Chaos.
Right.
And that, but then when they went to the school to set the school on fire, apparently before it started, didn't he hightail it out of there?
He managed to run away before the other 2 got caught by the victim in this case.
But there's no question, nobody has disturbed the basic fact that he then got the others to say, we got to go kill this guy, and he's the one that shot.
There's no disputing that, no. And they did a number of things. They got masks. They got a gun that they couldn't be traced. They changed the license plate on the car. He was in charge of all that and leading that cause. And he's the one that came up with the plan. They called information to get the address and the phone number, and they called the house to verify that that was the right house. And then they ended up going there.
Did anyone else get the death penalty?
No, Your Honor. The other 3 co-defendants all entered into plea deals and testified. They all testified at the trial.
Were they underage?
Excuse me?
Were they underage or? I mean,
One of them I think was, I'm not sure about the other two, but they all entered into, they all have life except Peter Magnetti. He got a lesser sentence than life.
Actually, this defendant was offered life without the
Correct.
possibility of parole, that he,
Correct.
and there's never been an issue that his rejection of that offer has never been attacked.
No, this court quoted the colloquy in the direct appeal opinion, I believe, in a footnote that they brought it up to the judge right before the trial and offered him a life sentence, and he didn't want to take it. Again, this is a very highly intelligent individual without any brain damage. Nothing that was produced in the evidentiary hearing would have changed the outcome in this case. Trial court properly found that counsel was not deficient. There was no prejudice in this case, and the state would ask this court to affirm.
I got two questions before we
sure.
sit down. Number one, there are a number of areas where it's challenged that there was no evidentiary hearing.
Correct.
Including one that involved some forensic evidence. Would you address that, number one? And number two, we've listened all morning to Ms. Bakus explain to us that this was a walking vegetable, that this individual had all kinds of signs of just all kinds of mess of problems. Would you address both of those?
Sure, I would gladly, and I'm glad you brought that up because it reminded me of something I forgot. There were no signs in this case. As counsel testified at the hearing, everybody was painting a picture of Foster growing up in a nice environment, no abuse, nothing. There was nothing there. They went with what they had, that he was a good kid that had helped, handicapped people and what have you. There were no signs. The alleged
You're saying
suicide.
now, if the defense team had just gone out to do some family background, I think that's what she's really saying.
Well, and they did. They called 25 witnesses at the penalty phase, including family members. 2 of Ruby Foster's husbands were called, including the one that had the most contact with Foster throughout his life, Brian Burns. The biological father had literally nothing to do with his life. They divorced, I believe it was 2 months.
Okay, that's fine. How about what were the relationships of the others that were called as witnesses?
The others was husband number 1, Newberry, and then they also called, well, they didn't call, they talked to a couple, aunt and a cousin out in Oklahoma or Texas. They didn't call them, but they talked to them. But Ruby Foster did provide a list of 75 people to counsel, and they called 25 of those people, but there were no signs from any of these. Everybody was telling counsel Foster grew up in a normal house and was.
Okay, and how about the forensic evidence?
The forensic evidence is shotgun shells, and her motion basically alleges that they could have presented evidence that they didn't do the normal testing of shotgun shells. The problem with that is shotguns are smooth bore and they don't have rifling, and that's what she was getting at. The testimony at trial was that the shell had been ejected from this particular shotgun. But there's really no issue about the shotgun in this case. We know it's Kevin Foster's shotgun. His fingerprints were on it. We know the victim was murdered with a shotgun. There's no debate about that. His defense was, I wasn't the one I didn't do it. I had an alibi. I was at home. It was the others that did it, not me. So the whole shotgun thing is really a red herring. There's nothing to the shotgun. I mean, we know there's no question it was his shotgun, his fingerprints, shells, what have you. So the rifling.
I understand that, the rifling issue.
And that was the only issue in that claim that wasn't addressed on direct appeal and wasn't already refuted in the direct appeal record, basically.
I have one question.
Okay.
Ruby Foster, defendant's mother.
Yes.
She was convicted of
conspiracy
to commit first-degree murder.
Correct.
She took out supposedly a hit on one of the witnesses.
My understanding is that there was a hit out on the judge, the prosecutors, the LME, a number of people in this case, and that was the reason why they moved to strike the judge originally, was the whole conspiracy to basically get everybody involved in the case.
Whom did she conspire with, supposedly?
The author of the book that they're relying on, Jim Greenhill, I believe. He was a reporter down there, and he wrote a book, and he got in with them, and he was involved in the conspiracy with.
Was he convicted as well?
I don't believe so, no. I believe he ended up cooperating with the state.
Do these kids have nicknames?
Yes, Mr. Foster was God in the Lord of Chaos leadership, the hierarchy. He was considered God. There are no further questions. Thank you.
Rebuttal.
First of all, the nickname you just referred to was not something that Mr. Foster gave himself. It was one that the rest of the members of this group of misfits gave each other nicknames. The group was loosely together a few weeks, less than a month before this crime happened. Lords of Chaos was actually a name from a video game, and it was a gang of misfit kids is basically what it was. And I mean, to suggest that this was some type of highly organized organization, it was not.
Well, I don't think anyone's suggesting that. It doesn't really lessen Mr. Foster's responsibility for what happened here. And I'm still not, what is it that the jury would have heard that would have said that he is not completely responsible and that the aggravation in this case is so substantial that it would outweigh any additional mitigation? I'm still not seeing it.
Okay. Well, first of all,
you're going to have to do it very quick. Give me your strongest point.
I'm doing my best to condense it. His chaotic upbringing and the life he led was not the life that was portrayed to the jury. And I think if the jury had 3 votes for life with the stuff that they heard already, had they heard what he had lived through, the emotional instability and the physical abuse that happened in the house, and there was physical abuse and violence. It wasn't a situation where this did not occur. Brian Burns, one of the people who testified, of course, he was never asked a question by anyone on the defense team, but he was the one who tore the house apart and stuck his hand through a plate glass window and broke the nose of Ruby Foster, in which Mr. Foster had to pull him off of her. He was also the role of pulling off John Foster, who was his stepfather number 4, when he was beating his mother. So this is not a situation where there was not violence in the house. And I didn't mean to suggest that Mr. Foster was a walking vegetable. I'm not saying that. But I'm saying, had the jury heard that he had deficits in the frontal lobe area, which is the area that controls emotion, response, impulse control, that could have explained why, when these 4 and 5 individuals got together, that they did things that individually they would never do. And those were the things that would paint the picture for the jury. They were entitled to know, and Mr. Foster, under the 6th Amendment, was entitled to an individualized sentencing by a jury who knew who he really was. And the only reason that wasn't done was because trial counsel unreasonably failed to send out the investigators to talk to the family members who were in Texas, Oklahoma, and the biological father who had extensive knowledge about the family history of mental illness and depression.
Thank you.
Those are the things that are missing.
Thank you for your arguments. Your time is well expired. Court is adjourned.
All rise.